state and national alike.
State and national, sir? I shall give you historical reasons presently, and the facts upon which these things stand, and I hope they will receive consideration. George Washington, I believe, is yet held in some respectful consideration. He is by the Seventh-day Adventists at least, and he said, quote, "Every man who conducts himself as a good citizen is accountable alone to God for his religious faith, and is to be protected in worshipping God according to the dictates of his own conscience." End quote. And so should we be protected, so long as we are law-abiding citizens. There are no saloon keepers among us. We are as a body for prohibition, and as for the principles of Christian temperance, we conscientiously practice them. In short, you will find no people in this country, or in the world, more peaceable and law-abiding than we endeavor to be. We teach the people according to the Scripture, to be subject to the powers that be. We teach them that the highest duty of the Christian citizen is strictly to obey the law. To obey it, not from fear of punishment, but out of respect for governmental authority, and out of respect for God, and conscience towards Him.
That is the common Mormon argument. The Mormons say their institution is a matter of religious belief. Everybody concedes their right to believe in Mormonism, but when they come to the point of practicing it, will it not be to the disturbance of others?
I should have come to that, even though you had not asked the question. But as you have introduced it, I will notice it now. My argument throughout is that the civil government can never have anything to do with men's duties under the first 4 of the 10 Commandments. And this is the argument embodied in Washington's words. These duties pertain solely to God. Now polygamy is adultery. But adultery is not a duty that men owe to God, in any way, much less does it come under any of the first 4 commandments. This comes within the inhibitions of the second table of the law of God, the commandments embracing duty to our neighbor. How men should conduct themselves toward their fellow men, civil government must decide. That is the very purpose of its existence. Consequently, the practice of polygamy, lying wholly within this realm, is properly subject to the jurisdiction of civil government. My argument does not in the least degree countenance the principles of Mormonism, nor can it fairly be made to do so. I know that it is offered as a very ready objection, but those who offer it as an objection, and as an argument against the principles upon which we stand, thereby make adultery a religious practice. But against all such objection and argument, I maintain that adultery is not in any sense a religious practice. It is not only highly irreligious, but it is essentially uncivil, and because it is uncivil, the civil power has as much right to blot it out, as it has to punish murder, or thieving, or perjury, or any other uncivil thing. Moreover, we deny that honest occupations on any day of the week, or at any time whatever, can ever properly be classed with adultery. There are also people who believe in community of property in this world. Suppose they base their principles of having all things in common upon the apostolic example. Very good. They have the right to do that. Everyone who sells his property and puts it into a common fund has the right to do that, if he chooses. But, suppose these men, in carrying out that principle, and in claiming that it is a religious ordinance, were to take, without consent, your property or mine into their community. Then what? The state forbids it. It does not forbid the exercise of their religion, but it protects your property and mine, and in exercising its prerogative of protection, it forbids theft. And in forbidding theft, the state never asks any questions as to whether thieving is a religious practice. So also as to polygamy, which is practiced among the Mormons. But let us consider this in another view. It is every man's right in this country, or anywhere else, to worship an idol if he chooses. That idol embodies his conviction of what God is. He can worship only according to his convictions. It matters not what form his idol may have, he has the right to worship it anywhere, in all the world, therefore in the United States. But suppose that in the worship of that God, he attempts to take the life of one of his fellow men, and offer it as a human sacrifice. The civil government exists for the protection of life, liberty, property, etc., and it must punish that man for his attempt upon the life of his fellow man. The civil law protects man's life from such exercise of anyone's religion, but in punishing the offender, the state does not consider the question of his religion at all. It would punish him just the same if he made no pretensions to worship or to religion. It punishes him for his incivility, for his attempt at murder, not for his irreligion. I repeat, the question of religion is not considered by the state. The sole question is, did he threaten the life of his fellow man? Civil government must protect its citizens. This is strictly within Caesar's jurisdiction. It comes within the line of duties which the Scripture shows to pertain to our neighbor, and with it, Caesar has to do. Therefore, it is true that the state can never of right legislate in regard to any man's religious faith, or in relation to anything in the first 4 commandments of the Decalogue. But, if in the exercise of his religious convictions, under the first 4 commandments, a man invades the rights of his neighbor, as to life, family, property, or character, then the civil government says that it is unlawful. Why? Because it is irreligious or immoral? Not at all, but because it is uncivil, and for that reason only. It never can be proper for the state to ask any question as to whether any man is religious or not, or whether his actions are religious or not. The sole question must ever be, is the action civil or uncivil?
Now apply that right to this case, to the institution of the Sabbath among men for the good of men.
Very good, we will consider that. Here are persons who are keeping Sunday. It is their right to work on every other day of the week. It is their right to work on that day, if they desire. But they are keeping that day, recognizing it as the Sabbath. Now while they are doing that which is their right, here are other people, who are keeping Saturday, and others who are keeping Friday. The Mohammedans recognize Friday. But we will confine ourselves to those who keep Saturday, the 7th day, as the Sabbath. Those who keep Sunday, and who want legislation for that day, ask that other people shall be forbidden to work on Sunday, because they say it disturbs their rest, it disturbs their worship, etc. And they claim that their rights are not properly protected. Do they really believe that in principle? Let us see. They will never admit, at any rate, I have never yet found one of them who would, that their work on Saturday disturbs the rest, or the worship, of the man who rests on Saturday. If their work on Saturday does not disturb the Sabbath rest, or the worship, of the man who keeps Saturday, then upon what principle is it that our work on Sunday disturbs the rest of those who keep Sunday? I have never found one on that side yet who would admit the principle. If their work does not disturb our rest and our worship, our work cannot disturb their rest or their worship. More than this, in a general Sunday convention held in San Francisco, at which I was present, there was a person who spoke on this very question. Said he, quote, "There are some people, and a good many of them in this state, who do not believe in Sunday laws, and who keep Saturday as the Sabbath. But, said he, the majority must rule. The vast majority of the people do keep Sunday. Their rights must be respected, and they have a right to enact it into law." End quote. I arose and said, suppose the Seventh-day people were in the majority, and they should go to the legislature and ask for a law to compel you to keep Saturday out of respect to their rights. Would you consider it right? There was a murmur all over the house, no.
Upon what ground did they say no?
That is what I should like to know. They were not logical. Their answer shows that there is no ground in justice, nor in right for their claim that the majority should rule in matters of conscience.
That does not follow. At least it does not strike me that it follows. The majority has a right to rule in what pertains to the regulation of society, and if Caesar regulates society, then the majority has a right in this country to say what we shall render to Caesar.
Very good, but the majority has no right to say what we shall render to God, nor has it any right to say that we shall render to Caesar that which is God's. If 999 out of every 1,000 people in the United States kept the seventh day, that is, Saturday, and I deemed it my right, and made it my choice, to keep Sunday, they would have not right to compel me to rest on Saturday.
In other words, You take the ground that for the good of society, irrespective of the religious aspect of the question, society may not require abstinence from labor on Sabbath if it disturbs others?
As to its disturbing others, I have proved that it does not. The body of your question states my position exactly.
You are logical all the way through, that there shall be no Sabbath. This question was passed me to ask, quote, is the speaker also opposed to all laws against blasphemy?
Yes, sir. But not because blasphemy is not wrong, but because civil government cannot define blasphemy, nor punish it. Blasphemy pertains to God. It is an offense against Him. It is a sin against Him.
Suppose the practice of it in society at large is hurtful to society?
That will have to be explained. How is it hurtful to society?
Suppose it be hurtful to society in this way: a belief in the existence of God, and reverence for the Creator, and the cultivation of that sentiment in society is for the good of society, is in fact the basis of all law and restraint. If the Almighty, who knows everything, or is supposed to, and has all power, has no right to restrain us, it is difficult to see how we can restrain each other.
He has the right to restrain us. He does restrain us.
To commonly blaspheme and deride and ridicule the Almighty would, of course, have a tendency to bring up the children who are soon to be the state in an absolute disregard of Him and His authority. Blasphemy, as I understand it, is that practice which brings the Creator into contempt and ridicule among His creatures.
What is blasphemy here would not be blasphemy in China and many other countries.
We are not dealing with pagan communities. A regulation that may be appropriate in a pagan community would not answer men in a Christian community. Do you mean that there is no such thing as blasphemy?
No, I do not mean that.
The Chinaman hardly believes in any God whatever, at least in no such God as we do. Taking our God and these Christian institutions of ours, what do you understand blasphemy to be?
There are many things that the Scriptures show to be blasphemy.
The power of the law has undertaken in various states to say that certain things are blasphemy.
Precisely. But if the law proposes to define blasphemy and punish it, why does it not go to the depth of it, and define all, and punish all?
Perhaps it may not go as far as it ought. You say you are opposed to all laws against blasphemy, cursing, and swearing.
In relation to any one of the first 4 commandments. Suppose that what is defined as blasphemy in the statutes of the several states should detract from the observance of the law and regard for it. Would you regard laws against it as being improper? Under the principle that the Scripture lays down, no legislation in any way can be proper in regard to the first 4 commandments. There may be many ways in which it would appear very appropriate for civil government to do this or to do that. But, when you have entered upon such legislation, where will you stop? Abstaining from blasphemy is a part of the education of the youth of the country. That is true. If youth are properly educated, they will never blaspheme. We pass laws for the education of the youth. The question is whether abstention from blasphemy could not be included in the scope of education. Take it on that ground. Idolatry, and covetousness as idolatry, is no more than a violation of the first commandment, quote, "Thou shalt have no other gods before me," end quote. And if the state can forbid the violation of the third commandment and the fourth, why may it not forbid the violation of the first and the second, and in that case supplant God at once, and establish an earthly theocracy? That is the only logical outcome.
Covetousness is a state of mind, but when it becomes practiced by stealing, taking from another without consideration, the law interferes.
Certainly. There is an infection in blasphemy or in covetousness. For instance, if one covetous man in a neighborhood should infuse the whole neighborhood with covetousness to such an extent that all would become thieves, then covetousness would be a proper subject of legislation. Never. You forbid the theft, not the covetousness. You cannot invade the condition of mind in which lies the covetousness.
We do not say that we must invade the condition of mind. But society has a right to make regulations, because those regulations are essential to the good of society. Society by a major vote establishes regulations, and we have to obey what is settled by the majority.
How shall it be discovered what is blasphemy, as it is only an offense against God? In the Puritan Theocracy of New England, our historian, Bancroft, says that, quote, the highest offense in the catalogue of crimes was blasphemy, or what a jury should call blasphemy.
But the law was behind the jury, and said that the practice should be punished. If a jury of 12 men said that one had committed the overt act, then it could be punished. It was the majority who made the law, and the jury only found the question of fact after the law had been violated. The jury did not make the law. This is a question as to making the law.
It is not wholly a question only of making the law. The question is whether the law is right when it is made. There is a limit to the law-making power, and that limit is the line which Jesus Christ has drawn. The government has no right to make any law relating to the things that pertain to God, or offenses against God, or religion. It has nothing to do with religion. Blasphemy, according to Judge Cooley, in his Constitutional Limitations, quote, is purposely using words concerning the Supreme Being, calculated and designed to impair and destroy the reverence, respect, and confidence due to him as the intelligent creator, governor, and judge of the world. A bad motive must exist. There must be a willful, malicious attempt to lessen man's reverence for the deity, or for the accepted religion. End quote. It is seen at a glance that this comes from the Old English system of statutes regulating, quote, offenses against God and religion, end quote. That is where the statute is placed in every system of civil law. It could not be placed anywhere else. But offenses against God are to be answered for only at his tribunal, and with religion, or offenses against it, the civil power has nothing to do. It is a perversion of the functions of civil government to have it made a party to religious controversies. It will have ample exercise for its power and jurisdiction to keep religious disputants as well as other people civil, without allowing itself ever to become a partisan in religious disputes and a conservator of religious dogmas. But according to Judge Cooley's definition, blasphemy is an attempt to lessen man's reverence, not only for the deity, but for, quote-unquote, the accepted religion, as well. But any man in this wide world has the right to lessen man's reverence for the accepted religion, if he thinks that religion to be wrong. Consequently, as I said a moment ago, that which would be counted blasphemy here would not be counted blasphemy in China, and that which is in the strictest accordance with the Word of God and the faith of Jesus Christ here, is necessarily blasphemy in China, or in Turkey, or in Russia. A man who preaches the gospel of Jesus Christ in China commits blasphemy under this definition. He does make a willful attempt to lessen man's reverence for their accepted religion and for the deities recognized in their religion. He had to do so if he is ever to get them to believe in Christ and the religion of Christ. He is to bring them to the place where they will have no reverence for their deities, or for their accepted religion, before they ever can accept the religion of Jesus Christ. It is the same way in Turkey, or any other Mohammedan country, or any heathen country. Wherever the gospel of Jesus Christ is preached in any Mohammedan or heathen country, it is blasphemy under this definition, because its sole object is not only to lessen man's reverence for their deities and for their accepted religion, but to turn them wholly from it, and if possible to obliterate it from their minds. It is so likewise in Russia. Anybody there who speaks against the accepted religion, or against the saints, or their images, is subject to the penalty of blasphemy, which is banishment for life to Siberia. But if blasphemy be a proper subject of legislation by civil government, if it be right for a government to make itself the, quote-unquote, defender of the faith, then it is perfectly proper for the laws of China to prohibit under whatever penalty it pleases the preaching of the gospel of Jesus Christ within the Chinese dominions. because its effect is to lessen men's reverence for the deities recognized by China, and for the accepted religion of the county. It is the same way in any of the other countries named. And in that case there is no such thing as persecution on account of religion. The only persecutions that have ever been, were because of men speaking against the accepted religion. If this principle be correct, then the Roman Empire did perfectly right in prohibiting under penalty of death the preaching of the religion of Jesus Christ. Whenever Paul, or any of his brethren, spoke in the Roman Empire, they blasphemed according to the Roman law. They were held as blasphemers, and were put to death under the very principle of this definition, which is the principle of the American statutes on the subject of blasphemy. The Christians had to tell the Roman Empire that the Roman gods were no gods. They had to tell the Roman Empire that the genius of Rome itself, which the Roman system held to be the supreme deity, was not such, but that it was subordinate, and that there was a higher idea of God and of right than the Roman Empire or the Roman law knew anything of. They did speak deliberately against the chief deity of Rome, and all the gods of Rome. They did it with the express purpose of destroying reverence for them and for the accepted religion. Rome put them to death. And I repeat, if the principle of the American statutes against blasphemy is correct, then Rome did right. To make this clearer, I quote a passage from the Supreme Court of Pennsylvania in defense of this principle, in a decision upon this very subject, which says, quote, "To prohibit the open, public, and explicit denial of the popular religion of a country is a necessary measure to preserve the tranquility of a government," end quote. That is precisely what the Roman Empire did. Christianity did openly, publicly, and explicitly deny the popular religion of the country. It did it with intent to destroy men's reverence for the deities and the religion of that country. Rome prohibited it, and upon the principle of the decision of the Supreme Court of Pennsylvania, which is the principle of American law on blasphemy, Rome did right, and Christianity was a blaspheming religion. The principle of this decision seems to be that those who represent the popular religion of a country have so little of the real virtue of the religion which they profess, that if anybody speaks against it, it is sure to rouse their combativeness to such a degree as to endanger the public tranquility. Therefore, in order to keep civil those who represent the popular religion, the state must forbid anybody to deny that religion. This decision of the Supreme Court of Pennsylvania is one of the grand precedents that have been followed in all the later decisions upon this subject in the younger states, but this decision itself followed one by Chief Justice Kent of the Supreme Court of New York in 1811, in which he embodies the same principles. He defends the right of the state to punish such offenses against what he calls a Christian people, and not equally to punish like offenses against the religion of other people in this country, by the following argument, quote, "Nor are we bound by any expressions in the Constitution, as some have strangely supposed, either not to punish at all, or to punish indiscriminately the like attacks upon the religion of Mohammed, or of the Grand Lama, and for this plain reason, that the case assumes that we are a Christian people, and the morality of the country is deeply engrafted upon Christianity, and not upon the doctrines or worship of those impostors," end quote. This is only to argue that, if the morality of the country were engrafted upon the religion of Mohammed or the Grand Lama, and Christians were to speak against and deny that accepted religion, it would be proper that the state should punish those Christians for so doing. If that principle be correct, then a Mohammedan country has the right to prohibit the preaching of the gospel of Jesus Christ within its limits. According to these decisions, Luther and the reformers of his day were blasphemers. The penalty was death, in many cases at the stake, yet under this principle the state did right to put them to death in whatever way the law prescribed, because they did certainly make an open, public, and explicit denial of the popular religion of every country in which they lived, and of all Europe. And if the words of Luther were used today in any Catholic country, they would be counted as blasphemous, as a willful and malicious revealing of the accepted religion. The reformers did hold up to ridicule and contempt the popular religion of all Europe. They did right too, and when the state punished them, it was but carrying out the principles upheld by Chancellor Kent and the Supreme Court of Pennsylvania, and all the other states that have legislated on the subject of religion. As I have already stated, it was upon this principle precisely that the Roman Empire forbade the preaching of the gospel of Christ. It only forbade an open, public, and explicit denial of the popular religion of the country, yet in forbidding that, it forbade the preaching of the gospel of Christ. But Christ sent forth his disciples to preach the gospel to every creature, and they did it in the face of the Roman law, and in opposition to the whole power of the Roman Empire. And everybody in all the world has an undeniable right to make an open, public, and explicit denial of the popular religion of this country, or any other, if he think that religion to be wrong. The principle of these decisions and of the civil statutes against blasphemy is essentially a pagan principle, and not a Christian principle. It is peculiarly appropriate, therefore, that Chief Justice Kent not only cited the precedents of the church and state principles of the colonies and of the British government, but appealed to the pagan governments of antiquity and the papal institutions of modern Europe, as the basis of his decision. It is true that all these nations have set themselves up as the special guardians of their deities, and have prohibited the denial of the popular religion, and it is equally true that all these nations have resisted every step in enlightenment and progress that has ever been made in the march of time. Every step forward in religion and in enlightenment has of necessity been taken in the face of all the opposition which these states and empires could bring to bear. But the principles of American institutions are neither pagan nor papal. The principles of the American Constitution which forbids legislation on the subject of religion are Christian principles. And it is strictly in order for Supreme Courts in making decisions in behalf of what they boast of as the Christian religion, to base their decision upon something else than the course of the pagan governments of antiquity, and the papal institutions of modern Europe. Upon such a subject it would seem to be proper for them to refer to the teachings and the principles of the author of Christianity, but singularly enough, it has never been done, and doubtless for the very good reason that it never can be done. For the teachings of Jesus Christ are directly against it. His word forbids civil government to have anything to do with what pertains to God. And instead of teaching his disciples to prosecute, to fine, and to punish by civil law those who speak against them, or their religion, he says, quote, "Love your enemies, do good to them that hate you, pray for them that despitefully use you and persecute you, that ye may be the children of your Father which is in heaven." End quote. How can men be brought to respect God or Jesus Christ by civil penalties upon their bodies and goods? How can they respect the religion of men who are ready to prosecute and imprison them? Every principle of the thing is contrary both to the spirit and the letter of Christianity. The religion of Jesus Christ properly exemplified in the daily lives of those who profess it, is the best argument and the strongest defense against blasphemy, both as defined by the Scriptures and by the civil statutes. Laws, therefore, prohibiting, quote-unquote, what a jury may call blasphemy, are pagan, and not Christian. The decisions of the Supreme Courts of New York and Pennsylvania upon this subject are pagan decisions, and not Christian. They are based upon pagan precedents, not Christian. The deadly persecutions of all history, pagan, papal, and so-called Protestant, are justified in these decisions. Michael Servetus was burned for quote-unquote blasphemy. The only use that ever has been, or ever is, made of any such laws in any country, is to give some religious bigots, who profess the popular religion, an opportunity to vent their wrath upon persons who disagree with them. Any man who really possesses the religion of Christ will have enough of the grace of God to keep him from endangering the public tranquility when his religion is spoken against. Therefore, I say that we are opposed to all laws of civil government against blasphemy, not because blasphemy is not wrong, but because it is a wrong of that kind with which civil government has nothing to do, and in this, we stand wholly upon Christian principle. We stand exactly where the early Christians stood. For I say again, when Paul spoke in the Roman Empire, he was blaspheming according to the law, was held as a blasphemer and an atheist, and was put to death as such, under the very principle upon which the American laws of blasphemy are sustained.
The law was wrong, you say?
Certainly the law was wrong. The Roman law was that no man should have particular gods of his own, gods not recognized by the Roman law.
That law was not for the good of society?
No, sir.
Certainly it was not. Then you have to repeal the law or obey it.
It ought to be repealed.
During these 1800 years, we have contrived to repeal that law. But here comes an intelligent people who have evolved among themselves, as the result of 1,000 or 1,500 years of history, among other things, the institution of the Christian Sabbath, by writing it in the laws of every state in this country, so that the whole American people made up of communities or states have enacted the principle of this law.
The same principle as under the bill before the committee? There is the same principle under it all. If you can legislate in regard to the Sabbath, you can legislate in regard to blasphemy, you can legislate in regard to idolatry, and every other offense against God, as did both the Puritan and the papal theocracy.
You deny the right of the majority, in other words, to make a law in conformity with which the whole shall practice in society.
I deny the right of any civil government to make any law respecting anything that pertains to man's relationship to his God, under the first 4 of the 10 Commandments. I wish right here to show further that this is not only the principle of the Word of Jesus Christ, but also of the American Constitution. Before Christianity was preached in the world, the Roman Empire had among its laws these statutes, quote, 1. No man shall have for himself particular gods of his own. No man shall worship by himself any new or foreign gods, unless they are recognized by the public laws. 2. Worship the gods in all respects according to the laws of your country, and compel all others to do the same. But hate and punish those who would introduce anything whatever alien to our customs in this particular. 3. Whoever introduces new religions, the tendency and character of which are unknown, whereby the minds of men may be disturbed, shall, if belonging to the higher rank, be banished, if to the lower, punished with death. End quote. The Christians did have a particular God of their own, not recognized by the Roman law. They did introduce a new religion. The Roman Empire enforced the law, and that is why the Christians were put to death. If things pertaining to God be a proper subject of legislation by civil government, then no Christian was ever persecuted, and there has never been persecution in this world.